to do that. Right, we're recording now, right? So this is LAWS12066 land law. And tonight in the tutorial, we're discussing topic 3, exceptions to indefeasibility of title. And we're also specifically concentrating on tutorial problems 5 and 6 in that review. Look, let me just say a couple of opening remarks, and I'm actually then going tonight, I'm going to actually start with a little exercise for you, spontaneous exercise, right, before we actually get to the two problems. This is a huge topic. You know, I mean, I won't walk away from that. It is a huge topic, the exceptions to indefeasibility of title, and there are a variety of exceptions there. You know, the two big ones, there are others, there are a few, and we'll just refer to those as we go along, but the two big ones, of course, as we know, you hopefully appreciate now from your readings and your review, fraud exception, which is within the remit of the legislative provisions of the LTA, and then what's been referred to as the in personam exception, or the personal equity exception. And what's interesting about doing that within the jurisdiction of Queensland as the benchmark jurisdiction that we're referring to is that in Queensland, of course, there is a provision within the LTA that deals with these matters in terms of equities affecting the indefeasible interest of the RP. So that has to be borne in mind when one is thinking about the in personam or personal equity exception in Queensland, because in every other jurisdiction where that isn't the case, which is almost most of them, there's one or two others that have it, I think Northern Territory has it, for example, but most do not, then basically it's the Fraser and Walker scenario of no, this provision about indefeasibility, and not every jurisdiction actually uses that word within the Torrens Act, as we saw in the last class. So it's not just the exceptions that are created within the Torrens Act itself, but it's also the personal equities that can also be brought as a basis for attacking that indefeasibility. But they are outside of the Torrens Act, okay? A recognition that that equity can still be maintained and is verifiable, right? The difference in Queensland is that that's now been incorporated into the LTA. So then the question arises, to what extent is the body of case law dealing with in personam exceptions that are outside the Torrens legislative framework relevant to a jurisdiction where this has been dealt with under the Torrens Act, and we don't actually have a body of developed case law on that provision and how that might be raise a different context for the operation of the exception than has historically been and is continuingly the case in other jurisdictions where this hasn't been incorporated into the Act. Hopefully we'll get to that tonight, but that's an interesting little puzzle. And the other thing I'll just say too, just as again as a bit of an opener, that I've read the responses that people have posted up on the Moodle website to the problems, and I thought it was interesting that particularly, for example, problem 5, which actually poses a scenario with a certain factual framework. I don't think any of the three of you, or the three that actually responded to that question, actually responded to the actual scenario. What all of you did was respond against the stock standard framework of case law, and you actually made an assumption which I don't think is actually borne out by the actual facts as I crafted them in a quite deliberate way. So that, we will get to that too when we get to problem 5. But just a point of reinforcement, you must respond to the question and to the wording of the question and to the wording of the factual scenario presented to you in the question, not what you think it should be about or not what you would like it to be about, okay? So just be very careful about that, Make sure you're engaging with the key words or the key concepts in the question at hand or the factual scenario as crafted, okay? Then bring in the law and bring in the legislation and the case law and so on as appropriate in responding to that particular situation. All right, now, I just said we'd start with a little exercise, and what I want you to do is, and I do this with a lot of groups, actually with a group of lawyers that I was talking to in the city of Sydney just this week, on a slightly different theme, but around some of these ideas. I'd like you to take a sheet of paper. I don't know if you can see this, but I won't hold it up. Just take a sheet of paper, and I want you to create 3 columns, okay, down the page. So 2 lines and three columns, and then you got to put 3 words across at the top of each column. In the first column, I want you to write the word fraud, and in the second column at the top, I want you to write the word unethical. And then in the top of the third column, I want you to write the word unconscionable. Now what I want you to do, just for a minute or two, is I want you to write down some words under each of those words. Write down some words under each of those words. What do those words mean to you? And I'm not really looking at this point necessarily for book learning. Just what comes to mind? What comes to mind when you think of these words? I mean, some book learning might emerge, but just intuitively, what comes to mind? Fraud, unethical, unconscionable. Just jot some words down. All right. So can we have some suggestions for what words do you think of, or what words have you jotted down for fraud? If you're on low bandwidth and there's a problem with sound, you can always just post something on the chat. But maybe if you've turned the video off, then sound will still be okay. So. What words for fraud?
I had intentionally deceptive.
Yes, very good. Something else? Someone else?
I had deceit, dishonest, and criminal.
Very good. Lisa?
I don't like this game. I had exceptions to indefeasibility and criminal for fraud.
Mm. So deception or deceptive got a couple of Guernseys, and so did criminal. Oh my goodness. There we go. So that's interesting. Unethical. Give me a couple.
Immoral.
Immoral.
And professionals, lawyers, for example.
I thought professionals are ethical, not unethical. You'd be surprised.
Not based on some of the cases
You'd be surprised, and you I don't know whether you are being surprised, but the number of cases that you are reading in this area that involve professionals, lawyers, solicitors, legal practitioners doing the wrong thing, right? In a whole range of manifest ways. So that's interesting.
That's why I said it.
Indeed, sir, indeed. A few other thoughts under unethical?
Had professionals. I had immoral as well, and I had agents.
Okay. Luke, anything?
I had immoral there too, Michael.
Okay.
I had.
Okay, that's fun.
Outside a social standard.
All right, okay. Do you want to continue on, Luke, and just tell us about unconscionable? Give us a word.
I probably had deceit would be one thing that comes to mind.
Yep. Good. Lisa, unconscionable?
Yeah, I had dishonest conduct, and then I had down a Mardio case, because that's the one I always think of when I'm thinking of unconscionability.
Cesario Amadio. Well known and well loved in the law. Wonderful. That's excellent. Grant?
I had consumers, commercial, and the Australian consumer law.
Okay. Why do you think I've given you that exercise to start with?
No idea.
No idea. Okay. Any other thoughts?
Is that to try and stop us being rigid in our thinking?
Try what?
Is that to try and stop us from being rigid in our thinking?
Could be.
Trying to think outside the square?
Outside the square, sir. We're always trying to think outside the square. That's exactly right. Exactly right. Those words, I think, arguably are pretty fundamental words in this area of thinking about the basis upon which the law finds a way of challenging the indefeasibility of title, either through legislative means, so it's been incorporated into the legislation, into the Torrens legislation, or by an examination of the behaviour or conduct of the person who's acquired that indefeasibility of title, that is the RP, the registered proprietor, or a person acting on instructions or at the behest of the RP, the agent, right? And then the issue, of course, the extent to which the agent's behaviour and conduct itself can be sheeted home to the RP, and that then raises a number of issues about the nature of that relationship and, you know, to what extent authorised to act in certain ways and so on and so forth. And then the idea of unconscionability, which really means against good conscience. This idea is very much at the heart of equities intervention. It's examining the behaviour and the conscience of a person or of a legal entity and asking is there a basis in this idea of unconscionability? Very often, although there's debate about this as well in the case law and in the literature and the academic debate, as you will have discovered, about how central this needs to be. In terms of equity's intervention, what is it that equity is ultimately protecting at the end of the day, and why should it intervene? And what is the justification, for example, to intervene and to set aside, for instance, the indefeasible rights of the registered proprietor, which the torrent system otherwise guarantees. But we've seen that there are circumstances that will justify that. But it is, again, an examination of the behaviour and the conduct, but it is also an examination of how behaviour and conduct has not just manifested, but what has driven it from if you like, from within the person, and then the nature of how the scheme or the plan or whatever has been concocted is also subject to scrutiny and examination. All right, so the significance of this topic is can't be underestimated, because where you're able to successfully argue that you meet one of these exceptions to indefeasibility, and as we, apart from those that we've spotted already, there are others, like, for example, how we deal with volunteers under the torrent system, and there's specific provision within the Queensland LTA that deal with volunteers, again, in a way that's different to states that don't have specific legislative provisions, that refers to Section 180. The very important area of overriding legislation, because the Torrens Act, the LTA, is a piece of Queensland legislation, just like any other piece of legislation. What do we do in a scenario where a subsequent enactment is inconsistent with the Land Title Act to the extent that it overrides the indefeasibility provisions of that Act? So that's another important area of exception. Okay, and there's also some discussion toward the end of the topic on the idea of state guarantee of title and the registrar's power to correct the register in certain circumstances. All right, now let's go to tutorial problem number 5. Who'd like to have a stab at that to start with?
Well, considering you've already told us that we missed the mark, I'm not sure where to start now. I'm reading the
Well, that's a good response. What I would do is, if you've got your answer open and beside you, well, I haven't said, maybe I was a little bit too bold initially. Not that you've missed the mark in terms of discussing the issues that I think need to be discussed, but I think what's happened is that I don't think there's been sufficient application back to the way in which I've designed the actual question. So if we just start, before we get to your response, all right, again, this is, I've done this before, what are the critical phrases or the critical words, key phrases in the question itself, would you say?
Well, ethical, knowledge, awareness.
Yep. So the knowledge is being brought home to the RP, and all of those that posted responses, yep, you mentioned that, this idea of being brought home. But the sort of behaviour or conduct that's described, and the way that behaviour or conduct is described in this situation, how have I framed that for you?
Highly dubious.
And so highly dubious and
Unethical.
right. What did every response to this question assume that meant?
Fraud.
Fraud, yes. Does it necessarily mean fraud?
Not necessarily. However, in the context
Yeah.
of the origin of that expression of being brought home, both in terms of, I can't think of the name of the case in the case book, but that refers to an English, a Privy Council case.
Yes.
That is relating to fraud by an agent, a practitioner.
Yes.
So I've answered the question in that vein, from the point of view that it was about fraud.
Yes, I know. And the challenge there, of course, is that you have to draw the link across, which you and others didn't. And the context of being brought home was a little bit of the trap, I suppose, because that's the very context within which the fraud idea has been discussed, for example, in Assets and Mere Rohai, which is an early Privy Council decision. Fiona, welcome. Welcome. You've just missed our exciting little word association exercise that we started with, but we might come back and mention that for you in a moment. So we're just discussing problem 5 in topic 3. So this idea of this knowledge being brought home and the conduct of, in terms of the practitioner being aware of highly dubious, unethical scheme perpetrated by the vendor of a third party. So the point that this is really trying to tease out is that sort of behaviour sufficient to constitute fraud for the purposes of the exception under the Torrens provisions?
Yes.
Anyone else? Lisa?
Sorry, are we referring to agency principles here? Because I've said that it depends on whether the agent is acting within the scope of his authority. Will depend on whether fraud can be brought home to the principal.
Well, the agency point is not entirely, not germane to this, in the sense that, of course, practitioner can only be acting on instructions, should only be acting on instructions from their client, in this case the RP. But would the RP have given instructions with respect to some dubious or unethical scheme? Is that something that the RP would have instructed on? And also the further point with regard to what about the relationship, so that this vendor of a third party who happened to be an acquaintance of the legal practitioner who claimed an interest in the land, is that part of what one would expect the practitioner as agent of the registered proprietor would be within the agency, in relationship?
Absolutely, and for several reasons. There's a legal obligation to legal practitioners to behave ethically. If they become aware of something, if they're acting for somebody, they do have an obligation to advise them and make them aware of it. The law will hold the agent or the practitioner as inputting notice on to the RP. So if they're aware of it, even though they're not receiving instructions on it, the RP is not necessarily going to instruct, look, if you become aware of something unethical, I want you to tell me. There's an implied expectation that that's going to happen automatically.
What is really going on here, do you think? Let's boil it right down to tin tacks.
Yeah, I was just going to say, is the practitioner presumed to have informed the client, regardless of whether
Do you think the practitioner would have informed the client?
I don't know.
Would you have informed the client if it was you?
Probably.
So you would have informed the client?
Definitely, but there's a conflict of interest here.
You would have informed the client of information or an understanding that you had about a dubious or unethical scheme involving the vendor in relation to someone who happened to be a friend of yours. I'm not saying what what the ethical rules require. I'm saying, what would you do practically?
Reconsider my friends.
Well, you know, I don't know. I mean, maybe you may well. Sorry, yes, Lisa?
It's difficult to say unless we're in that position, and we don't have years of practice to form a proper view on it. I think it's difficult unless you're put in that position by your friends to know exactly what you would do.
But you can think of whether you prefer, in terms of, when I say prefer, I mean putting in order of priority or in order of preference, friendships as opposed to professional obligations. Because this is often what lies at the heart of people going astray and doing the wrong thing. So why is it that solicitors, for example, and practitioners, why do they forge signatures? Why do they have interests in land going to someone that's related to them or going to a friend of theirs? You know, what's intention here? I mean, ideally, of course, the practitioner should be doing what is professional and ethical in advising their client, in making them aware of the circumstances that are relevant, fulfilling those obligations to their client, acting in their client's best interests. But very often, of course, what sometimes happens is they actually prefer their own interest, or place it first, or place the interest or the financial interests of someone they're related to. And actually, in the end, when they're going down this path, they're becoming quite unethical. But the question then becomes as to, but is what they are doing or becoming involved in or helping to perpetuate, does that constitute fraud, where you're in a situation of, for example, a transfer of interest in land that then justifies that exception under the legislation which defeats the indefeasibility provisions within the Land Title Act? Because if that person to whom that solicitor practitioner may be related or friend, to whom the interest ultimately goes, and that interest is registered, do they get the protection under the Act, or can that transfer of interest be, and the indefeasibility be defeated or set aside, so that the unethical behaviour or whatever is sufficient to amount to one of the exceptions under the legislation, which is the one we really want to look at here is fraud. So what I'm really throwing up here is where is the standard to be arrived at in terms of what amounts to fraud for the purposes of that exception under the Land Title Act? Is involvement and knowledge of a highly dubious or unethical scheme, is that enough, or is more required? Right? Is the facts that link the practitioner and knowledge of this scheme being perpetrated, in this case on the facts by the vendor, and the acquaintance or the friendship of that to the practitioner, does those sort of facts justify and are sufficient to give rise to the fraud exception, to set aside the indefeasibility that ultimately would be acquired by the transferee where the interest is registered? What do you think? What do the courts say is required to satisfy the fraud exception?
Isn't it knowledge? Knowledge, notice, awareness.
Isn't it really focusing more on the conduct and behaviour, Lisa?
I was just going to say something more than mere notice.
Yes, certainly. Just having knowledge is not of itself enough. Go back to, there's been several cases that have dealt with this, and if you look at the, under the fraud discussion there in the notes, as early as the Lockhew case back in 1913, where the Privy Council spoke about fraud and this idea of being moral turpitude, doing things in a willful way, knowing that what they were doing was unacceptable and contrary to, if you like, dealing with people in a way that was proper and lawful. There was this idea, as you mentioned earlier, dishonesty and deceitfulness within the way in which matters were being handled, and so on and so forth. These are the ideas that resonate with what is required to prove fraud under the Land Title Act. Now remember that fraud is a word that can be used generally, it can be used in general law. We can also talk about categories of fraud. We can talk about, fraud understood in the general law. We can talk about, for example, equitable fraud. But in this case, we are talking about fraud as used within the parameters of the Land Title Act, within the Torrens Act itself, as a acceptable legislative exception to indefeasibility of title. And we have to ask, what does it mean in the context of the Torrens legislation? And even, for example, this comes up, in the second problem question, but Barr and Nicolay number 2, which was a 1982 High Court decision and a very significant one, where the idea of fraud was discussed and what that meant and how do we understand fraud. And so, for example, the bottom of page 16 of my notes, there's a reference there to this idea of fraud being personal dishonesty, moral turpitude, which lies at the heart of the sections and their counterparts. This is the equivalent of the provision within the Land Title Act. All right? And an attempt to try to work out what that means. Very interesting, of course, in Barr and Nicolay, the judgment goes on to talk about how should we construe the language in this context. and the judgment there of Mason and Dawson talk about that the section that they were looking at, which is not significantly different from the section in the LTA, should be strictly or construed strictly and the exception liberally. The exception, of course, in this case relates to fraud. Granted that an exception is to be made for fraud, why should the exception not embrace fraudulent conduct arising from the dishonest repudiation of a prior interest, which the registered proprietor has acknowledged or has agreed to recognise as a basis for obtaining title, as well as fraudulent conduct which enables him to obtain title or registration? But of course, you know, these cases dealing with fraud, and there are others there, of course, as well, in the materials that you've got and in the notes and so on. Of course, they're always talking about fraud, right? And how we should understand that within the confines of the Torrens Act, whichever one we happen to be looking at. And then we're examining the behaviour, the conduct of those whom it is alleged that have been fraudulent, which might justify the title being made defeasible and therefore not attracting the indefeasibility of title. But the question is, going back to the facts of our problem question that I posed for you, and that is the problem question 5, whether this awareness of a highly dubious, unethical scheme and the relation and the link that the legal practitioner has to the vendor through being a friend, if you like, whether that's enough to amount to fraud for the purposes of the Land Title Act. I think, Grant, did you say yes it was before?
I said yes, it was, because it's inputted. They have become aware of it. So if they're acting, it's the agency that comes into it. If they're acting on behalf of the RP, then that knowledge is inputted to the RP, whether they like it or not. It's not fair and it's wrong and it's unethical that the Torrens system is designed to protect an innocent RP, except, I guess now taking it further, if the agent is unethical, well, then the RP has recourse against the agent.
Yes, but the point here is that, putting to one side the issue about regulatory control over ethical behaviour of practitioners, which is a separate point, is dubious and unethical or involvement or awareness of a dubious or unethical scheme and a relationship to between a vendor and a legal practitioner, when the legal practitioner is acting for a registered proprietor, right? Was that enough to amount to fraud for the purposes of the LTA? Or do we need more? That's really the point. Is that enough? Fiona, you got any thoughts? Silencio. That's right. What I've done here, people, is I have deliberately cast this in a way to challenge whether or not this amounts to fraud. Right? If I'd made it more straightforward, more plain, you know, it's not really, we're not really being challenged. How do we apply that understanding of fraud that has been given to us by the courts? I think that when I took you back to Barr and Nicolay, because Barr and Nicolay, of course, is relevant, is relevant for both the fraud exception and the in personam exception. But in terms of fraud, I just, that, you know, and again, of course, you need to go back and look at the factual scenarios of some of these cases and correlate against some of those, and that's true. But the point that was made that I teased out just before, which is on page 17 of your notes from the extract from a bit of the judgment I've given you, the section, and this is the section they're focusing on, that is the section that's dealing with fraud, right? It's not in the LTA, but the equivalent, and the wording is almost identical. The section should be construed strictly and the exception liberally. Now, does that approach lend itself to Grant's conclusion that yes, this sort of behaviour, this sort of involvement, this sort of awareness, that's enough. That's enough. That's fraud through that sort of legislative interpretive approach. Elisa, yes, please. Yep.
Sorry, I was just going to say, well, yes, it does, because if we're construing fraud liberally, then dubious and unethical behaviour does amount to fraud.
And yet what's interesting is that at the same time, Barr and Nicolay, and also Assets and Mir Rohai, and the cases that go between those two decisions, and there's about 70, 80 years of case law, both from London and in Australia, several cases. They talk about fraud requiring, and being defined in terms of moral dishonesty, moral turpitude. I mean, even, for example, more recently in the decision of Macquarie Bank and 64th Throne, and that was a Victorian Court of Appeal decision. This is page 343 of APL. Right. But at the bottom of page 344, Tadgell, Justice Tadgell, or Justice of Appeal Tadgell, refers to the idea of willful blindness in the context of thinking, discussing fraud within the context of the Victorian Torrens statute. Now, again, this exception is uniform across the Torrens Acts, fraud being exception. That's not an issue. There are some other nuances of difference between the Torrens legislation and other jurisdictions in Queensland, but this fraud exception, no, that's there. It's in all the acts. So he talks about willful blindness. And then when you come across to the significant High Court decision of Farrer Constructions and Say-D, starting on page 374 of APL, you will find again that that is a case discussing both the fraud and the in personam exception. But on fraud, and again, this comes from the New South Wales jurisdiction to the High Court, but the exception, fraud, within the New South Wales equivalent, the High Court is telling us means actual fraud, moral turpitude. Now that takes us back to the Assets and Mir Rohai case, this idea of moral turpitude. See, one of the challenges that's going on here is that the courts themselves, because the legislation doesn't define what fraud means, right? You yourselves have started through that exercise I gave at the beginning of the class of identifying what you think of when you hear or see or read the word fraud. It's not too far away from what the judges are trying to say fraud means, right? But it's interesting that, for example, they use this phrase moral turpitude. So what are they suggesting? They're suggesting that statutory fraud under the Torrens Act involves some sort of immorality. immoral, immorally conceived behaviour or conduct? Is that what is necessary? Because if that's what is necessary, then I would suggest to you that something that is unethical, whilst not acceptable, is not necessarily as extreme as that is, moral, whatever this moral turpitude means. The point is that what the courts are doing is trying to set parameters around behaviour and conduct and action that a society will countenance as acceptable or not. That's what's really happening here. And they're using a framework of language and linguistics, put it as high as linguistics at times, to craft that. But fraud is pretty high in terms of the order of unacceptable way of doing things and behaving and conducting yourself, because it does rank with it these ideas of willfulness, if you like, and deceit and doing things that are very, very much beyond what is going to be countenanced as acceptable. Right? It's interesting that a couple of you indicated criminal. It may be that, but it may not necessarily be that, by the way, in all cases. So that's what I was trying to get you to think about a little bit in the context of that. Of course, we've only actually looked at the first part of the question, haven't we? There's two parts to this question. And the second part of problem 5 asks, if the practitioner fails to advise their client, who is the RP, of this scheme, will that be enough to deprive the RP of the benefit of indefeasibility? Well, I suppose we have really engaged with that. That's getting you to think about the standard of behaviour, right, and how it gets applied. But the other thing that's important here is that, and I'm going to toss this back to all of you to does it make a difference that we're talking about a legal practitioner? Because not all the cases involve this sort of behaviour by a legal practitioner or a solicitor. Does that make a difference?
No. And the reason that I say that is that in all of the cases, the RP and the agent or solicitor are spoken about in the same breath. It's a marriage for better or worse. If you have a bad agent, it's tough luck.
All right, thanks, Grant. Anyone else? Fiona, any thoughts? Fiona's keeping her counsel tonight. Luke, any thoughts?
Sorry, I've just got kids running everywhere.
That's all right. That's all right. No problem. You can put a...
My thoughts, Michael.
Yes, please. Yep.
My thoughts are no, it doesn't necessarily have to be a solicitor or legal practitioner. The Lock U case was an agent acting for the principal. I think it was Shelton Corwell was a legal practitioner in that pretty similar scenario to the one in the question. So across both of those cases, the same outcome from my reading.
Let me put this back to all of you. Do you think the standard should be the same for a legal practitioner and a person who is not a legal practitioner?
I would think that the legal practitioner is held to a higher standard.
Thank you, Luke. Someone else? Lisa?
Yeah, I was going to say that, yes, I was going to say that a legal practitioner should be held to a higher standard. And I'm just wondering whether you were sort of trying to get us to say, I wonder whether that behaviour would breach the solicitor's conduct rules.
Well, that's another matter, of course, and thank you for raising that. Of course, the fact that I've tossed in unethical may hint at the fact that there could be ethical issues here for the practitioner, okay, which the practitioner has to comply with in addition to other, possible implications of how they're conducting themselves more generally. Don't forget also, people, and interestingly, Grant tossed this up under the word unconscionable. He referred to the Australian consumer law. Don't forget that in the provision of services, clients can be seen as potential customers for the purposes of the application of the ACL, which is touching broad areas of law now. And if that's considered to be unconscionable conduct pursuant to the ACL, then there could be action under that. But we'll put that to one side for a moment. But you need to be ever mindful of the implication of the ACL and the CCA in many areas of law today. I want to put back to you that in fact it is appropriate, and the law and courts do hold people like legal practitioners to a higher standard, and rightly so, because of the obligations that they owe to their clients, because of their special position of trust, and because, in truth, they really carry those special obligations of fidelity and being a trusted person. And often that's what's exploited by those who are not thoroughly ethical in the way they go about how they function as a practitioner. And they exploit it. And sometimes they exploit their clients, and that's a thing that is totally an antithesis to what they should be doing as a practitioner. But I think that you will find and discover that the courts do hold practitioners to a higher standard. But the point, I think Luke brought this out, that yes, one reviews the case law and one sees examples of practitioners involved and one sees examples where practitioners aren't involved, and the conduct and the behaviour needs to be examined. The conduct and the behaviour of the RP certainly needs to be examined in the context of allegations or suggestions that the indefeasibility of title should be set aside or should not be indefeasible but should be defeasible for reasons of fraud. The point that's been tossed up with regard to the agency between a practitioner and their client, or indeed someone acting for an RP, not necessarily a practitioner but even someone else, and Luke I think mentioned this, that also and how that agency relationship bears on the question. And then what gets sheeted home ultimately to the RP, because it's the RP that will bear the cost if their interest is made defeasible. And this is why the case law is often so agonised out, because what we're thinking, what the courts are grappling with is the implications. If you make the interest of the RP defeasible, you're actually defeating the protection that the Torrens Act has given that RP. And this idea of what is on the register should be what reflects, I emphasise should, I know not everything is on the register, but should be what reflects the quality of interest that the RP has. That's a hallmark of the system. But of course, we know from the Bursell case, that early decision where we have the complex transfer instrument and the suggested right of way with the building over the right of way, and not all of that information obviously being on the register, but you had to go and then search the transfer document and see it. The suggestion by difference of opinion actually between the judges there in that early High Court decision in Bursell and Brothers case. What should you do? Should you be relying on the register, or should you make appropriate inquiries? And Windy is saying, well, of course, an informed and a competent practitioner would make those inquiries, and one would expect them, and a client would expect them to do so. But arguably, that's defeating the curtain principle under the Torrens system, that they don't need to look behind the register. The register is everything. And yet, at the same time, we know that issues like unregistered interests and equities, these are not totally discounted and somehow need to, at different points, be thought about in terms of their involvement in the registered proprietor's interest at the end of the day. So that question was intended to get you to think about fraud and the boundaries of fraud under the Land Title Act, how we interpret the statutory idea of fraud for the purposes of being an exception to indefeasibility of title under the LTA, reflecting on some of the body of case law around that, and then putting it into a context that's not slightly on all fours with a fraud scenario, but then asking how far can you push that. All right, let's go on to problem 6, if we can. All right, so who would like to have a go at this? You did indeed, Grunt. You did indeed. All right. So let me turn it around a little bit. How about someone tell us a little bit about the facts of Bar and Nicolay, number 2?
Okay, I'll have a go at this.
Wonderful.
I can't stand the silence any longer.
Wonderful. Thank you, Lisa. Fill the void. Fill the void. Tell us about Bar and Nicolay.
Okay. The Bars sold some land to Nicolay on the proviso, because they couldn't afford to develop it at the time, that they could buy it back at a later stage. But Nicolay sold it on to the second respondent, which was the Thompsons, who refused to acknowledge the contractual clause in the contract. But it was
just go
held.
back. Sorry, can you just go back a step? So the bar, so just the first transaction or the first contract was between whom?
The Bars and Nicolay.
Right.
I think, wasn't it?
And was there anything in that contract that you need to point us to?
It was a clause giving them the right to buy back part of the land.
Right. So it was a buyback clause within the contract of sale, right, between the Bars and Nicolay. Did N become...
No, sorry, go on.
Is that right?
Yes.
Yes.
Right.
And N became the registered proprietor?
Yes, so Nicolay then sold it to the Thompsons.
Well, before we get to that, so N became the RP and N had the protection of indefeasibility, did he?
Yes.
We would think so. Registered as proprietor, initially at least, assumedly, without, if any, no exceptions apply. This protection in the contract, would that be on the register?
No, I don't think it was.
No? Any facility to put it on the register?
No.
No, because it's in the contract, okay?
Yeah.
And the contract is not the thing that gets registered. What gets registered is the transfer, okay? So it's the transfer instrument that gets lodged with Queensland Land Titles Registry. And as I discovered when I was up there a couple of week or so ago, that in fact it's not even an original document that's lodged with Queensland Land Titles, but what happens today, the practice of land titles in Queensland the registry is that you just submit a scanned-in version of the original, and the interest is recorded on the computerised register as a result of that, them receiving the scanned-in original. So they never actually cite the actual original document in paper form, and if they get a paper document, they actually destroy it. So they only keep scanned-in versions in electronic form. So there's nothing on that which would reveal this condition within this contract, right? So what happens next after that, Lisa?
Nikolai sold it to Thompson's.
Right.
And brought the clause, I think, to their attention.
Yes.
I think. But they refused to acknowledge it. Something and.
So.
Right.
In the second contract of sale, is that clause there as well or not? Or
I'm not sure.
Yes, Michael, that...
Was it there? It was, wasn't
Luke, yes. Can you come in?
Yeah, I can. Sorry, Lisa, I'm cutting in there. From my reading, it was that clause was acknowledged in the agreement regarding the repurchase, and that was subsequently confirmed orally.
That's right.
Back to Bar.
That's right. So in the second contract, that was confirmed, and it was also orally, confirmed as well. And then, of course, the problem happened in the end, of course, where the bars wanted to act on that clause in the contract. And what did the T, who was the RP at the time, basically, what did he do then?
Refused to resell.
Yeah, you basically said to the bars, well, I'm the RP now. You can go whistle for it. I'm the RP, and I have full indefeasibility of title under the Torrens Act. So, what are you talking about? I don't understand what you're talking about. Huh? So, in the end, what was in potential conflict here, legally?
the indefeasibility of title and whether the in personam exception applies to it?
Well, that's what the courts, that was the argument that presented to try and to attack the indefeasible title of T. But what was the basis of that? What was the basis of this? I mean, because, that's a, Latin phrase, in personam exception, personal. What was the nature of the equity that was being asserted by the bars?
Dishonest conduct.
There's more than that. What was it grounded in?
It was an equitable interest.
But yes, but what was it grounded in? What was the nature of that equity?
The contract.
Yes. What in the contract? What?
A promise? A promise
Good.
to sell the land back.
The condition in the contract. Now this takes you back, I think actually one of you maybe might have been granted the answer, referred to the contractual dimension here. Right? This takes you back to the fundamental thinking about contract. Contract is essentially an exchange of promises. Right? And there was a promissory undertaking here incorporated into the contract of sale, subsequently acknowledged by the first purchaser to the second or the first transferee to the second transferee, put it like that, I suppose, from Nicolay to Thompson, that's right. We understand that, right? That's in the contract. And we understand that agreement, right? That contractual undertaking, right? So that's on the one hand, and that's in tension now, or in conflict with the protection that the Torrens Act gives to a person who has a registered interest in land, the RP. The question then, before the Barr and Nicolay case, and we haven't got to the slight twist in problem 6, we'll get to that in a minute. In Barr and Nicolay was, well, how do we reconcile this? Do we say that on the one hand, the fact of being an RP under the Torrens Act defeats everything, and everything else that went before is just irrelevant? Basically, you can do whatever you like. Once you get that quality of registered proprietorship, nothing can attack it. It's impregnable unless there's an actual dedicated exception under the legislation, because you couldn't actually argue what's going on here, amounted to fraud necessarily. As you know, there was another way of. I mean, fraud comes up in the Barr and Nicolay case in terms of how it was discussed, but and how the action of conduct. We didn't know necessarily that it would qualify as a fraud, as an exception of fraud. What else could be argued? And this then gave rise to this idea of the personal equity, the fact that the undertaking had been given by Thompson, had been recognised by Thompson, of a contractual commitment, of contractual promise, condition in the contract, that needed to be abided by. The very fact that he then became the registered proprietor didn't negate that obligation. And this is what gave rise to the equity, and equity, and a court of equity would recognise that obligation, because it would be unconscionable actually not to let Thompson get away from recognising that commitment that they'd made through that contract and undertaking, just because he'd got the protections of indefeasibility by registering under the Torrens Act. And this is often the sort of conflict that's at stake. Is there a basis for saying that there is this personal equity that justifies saying that the interest now that this person has under the Act actually isn't totally indefeasible, and there are justifiable reasons? The implication in Queensland, of course, is that we have a provision within the LTA that deals specifically with personal equities, or with equities, which is not uniform. It doesn't exist in other jurisdictions. So that in Queensland, and this is on page 20 of your notes, section 1851A, sub 1, paragraph A, a registered proprietor of a lot does not obtain the benefit of section 184, which is the indefeasibility provision, for the following interest in relation to the lot: an equity arising from the act of the registered proprietor. Now, the Act, that is the LTA, doesn't actually define what it means by an equity arising. It doesn't, and that's, of course, a phrase which is not the same as the phrase that's been used in the case law since Fraser and Walker of right in personam or personal equity, and the circumstances that have given rise to that. And we don't have, a body of case law on Section 185. Certainly we have, as I've indicated to you in those, the White and Thomasell case, which is a 2004 Queensland decision, looking at the operation of the in personam exception in the context of Section 1851A. You can have a look at that. But it doesn't mean that all of that body of case law dealing with the in personam exception is not relevant, but we do have to put it into the context of the fact that we have a provision in the Queensland LTA that deals with this equity exception, if you like, to the indefeasible title that is otherwise acquired under 184 of the LTA. So going back to problem question 6, we must always go back to the keywords, to the situation of the question. I've tossed up this idea of, can keeping silent be taken to be an indication of assent to a condition, rendering the condition or stipulation enforceable. So that's not the same as bar and Nicolay, is it? It's a different scenario. Is that right? You agree?
Yeah, I think that's a different scenario.
Yeah, because in bar and Nicolay there was positive action, wasn't there? There was both, yes, I recognise the existence of this contractual condition, and oral agreement to abide by it. So there was positive reinforcement of it. What about if Thompson had said nothing and there was no conduct, there was nothing to indicate yay or nay, agreement or non-agreement? How should we proceed then? Is that different, or should be dealt with in the same way as on the facts of bar and Nicolay?
Michael, for mine, it comes back, it's standing out in Foundations of Property that there was a case that the lease was there and there was something in the lease, and because he hadn't read the lease, he was still to abide by it. So I'd probably, if it was written in the agreement, that person would still have to abide by what's contained in the lease, or the contract in this case.
That's nice. That's a nice. Would have been better if you given us the case name, but nice interlinking there, Luke, which is very nice. Good.
One semester at a time.
Indeed, sir, and I'm happy to give you that extenuation of circumstances. The other thing that I'd say to you, just generally, is you're looking for creative ways to use the law to apply to present a particular argument, right? That's how we use law to defend a position for our client, or to advocate a position for our client, or whatever. I mean, one thing, for example, that one might suggest is a different fact scenario, and you have to indicate this, of course. But for example, this has not been without criticism either, but in the Bursell brothers case, for instance, Windy has said, and I've already mentioned this, Windy has said that it wasn't good enough just to sit on the surface of the register. For example, you saw a reference to a transfer there, you saw a reference to something else. You needed, a conscientious practitioner would go and make an inquiry and look at that. Now, that's been criticised by saying, well, that's going behind the register and whatever. But in another way, you could argue that idea about what a conscientious person should do, so that, for example, when you sign a contract, you should read the contract. You should understand the contents of the contract, shouldn't you? Right? Oh, massive storm. Okay. I've been cold weather coming this way too, so we're not too much longer, Lisa, not too much longer. It's not unreasonable or going too far, I don't think, to say that a person that is entering into a contract, that is signing a contract, agrees to what's in the contract. Surely that's what the contract means. But yet at the same time, we know. Grant, yes?
I just wanted to touch on that point of the contract in terms of the clause and the phrasing of the condition, because it's one thing to have, you can have a clause, but a condition that imposes an obligation as opposed to a clause that is simply a notification about the existence of a tree on the property, or there is the existence of a dam, or there is the existence of an unregistered interest. There's a big distinction between simply, even if it's in the contract, a notice and an obligation. And that, to me, is the turning point, that if it's simply a notice, they would be able to defend that. But if it's an obligation that they've accepted as part of the contract, that's where the law, equity will step in.
But what about where they've been silent? How does that impact?
I would say it would depend if they're signing a contract where the wording of the clause is making it clear that there is an obligation, as opposed to simply providing a general notice. then signing the contract and not saying anything about that clause, you're accepting the contract warts and all. But again, to me, I think it's more in the phrasing of whether it's notice or a condition or an obligation.
That's good. That's good. I like that reasoning. Let me take you to, again, a slightly different twist on this, to the Parker and Mortgage Advance Securities, page 378 of APL, and paragraph 5.260. And that's a Queensland decision, 2003. And that's in the context of a mortgage. And many of these cases, although not exactly the ones we've been looking at, do toss up the mortgage scenario, right? But just in the context of what you were saying, Grant, in that situation, in terms of the mortgage, one of the issues that were thrown up was that, in fact, the mortgagor had been taken advantage of, had been dealt with in an unconscionable way. The representatives for the mortgagee said, well, wait. We've got a document here that has been signed, has been explained by the solicitor to the client, mortgagor, and has signed saying they have read and they have understood what they've signed and they understand the implication, etc., etc. And then when you come down to the bottom of page 379 and over to the top of 380, this is what Justice Davies had to say. So just in the context of what you were saying there, Grant, just as a further dimension, the form of the certificate gives some cause to doubt the care with which the certifier satisfied herself about any of the above matters. It was in a standard form, appropriate whether the borrower was male or female or a company. It was incorrectly executed, so on and so forth. All right? It is true that the certificate was provided by a solicitor whom the respondent knew was independent of it, but what the respondent did not know and made no attempt to ascertain was whether that solicitor was independent. The transaction had about it the hallmarks of one in which a person, weakened by at least by age, was prevailed upon by a younger and a stronger person to mortgage her property in an improvident way for the benefit of the younger and stronger person. Now, that's in a context of a mortgage, and it's in the context of going back to Lisa's point about Amadio, the famous and the great case of Amadio, in terms of exploitative behaviour against people of age or issues of education, and being exploited and taken advantage of, whatever. But the point, bouncing off what Grant was saying earlier, is that, of course, sometimes, and particularly in land sale contracts, and this is not my conveyancing course, but many of the terms and conditions in a land sale contract are standard printed terms on the contract of sale, and they are just replicated in contract after contract. But there can also be special conditions that are incorporated in the contracts, and if you sign, then you need to have read and understood, but the very fact that you have signed doesn't necessarily mean that you may have, of course. So where does that take us? It takes us to the fact that we do need to always consider the totality of the circumstances, the facts at hand. Grant's point earlier about the nature of what we're looking at, yes, absolutely, I agree with that. We need to differentiate between what we're looking at. But where we've had an undertaking or a commitment, then a promissory obligation has been entered into, then you cannot resile from that. Of course, the point about silence twists out or tosses out the idea, does that make a difference? Well, it depends on the circumstances. Again, we need to examine the conduct and the behaviour of the contracting party because of the significance of the consequence of saying that this equity, pursuant, in this case, under the Land Title Act, under 185, 1A, actually leads to a defeasible outcome, and that the RP doesn't actually have indefeasibility of title. So that's a very significant outcome, okay, for the RP. But basically what the law is doing here through, in Queensland, through legislative provision, and you need to think about how that is slightly different to the position reflected in the body of case law coming from jurisdictions where it's not reflected in the Torrens Act, how that gets recognised in the context of a system that secures the interests of the RP through this foundation idea of indefeasibility, which in Queensland under the LTA is, of course, specifically recognised by name, but again is not recognised in that same way by name necessarily in all other jurisdictions, as we know, or as we've seen. The truth of the matter is, people, at the end of the day, to questions of this nature, there is not necessarily, one answer, but it's how you seek to use the law to interpret the situation or the scenario to arrive at an outcome that most commends itself in all the circumstances. And that's what I'm looking for in your reasoning processes. And I'm hoping for a bit of, seeing into the law in terms of what's happening here and how it can be applied in different circumstances to facilitate an outcome that is reasonable and equitable at the end of the day for the party you're advising or working in the interests of. Ever mindful that we live in an age of reform. Second, Devasy, can you please just mute your mic? You're not saying something. Please, you've got some background noise there. Thank you. So that's really, what that question was trying to get you to think about, and the leading case of Barr and Nicolay number 2 in the context of those types of exceptions in terms of the right in personam, personal equity, or equity as it's known under that provision of the LTA. As I referred to at the beginning of the class, there are some other exceptions that we need to be mindful of as well, and you should be aware of those. Overriding legislation, the Kumpa 2 case, 2008, important in terms of that area, and that's another significant area that potentially has the strength to undermine the indefeasibility of title. At the end of the day, the truth of the matter is, in the next class when we look at priorities and unregistered interests, we will come to understand that indefeasibility of title is a very significant aspect of the Torrens system. We need to understand it in the context of the particular Torrens statute that we're examining here in Queensland, the LTA. And even though it indicates that, this is puts the RP in an extremely strong position in terms of the quality and the characteristic of their interest in land under the Torrens framework, it is not invincible or impregnable against all other possible interests or rights or entitlements. And those situations will need to be examined on a case-by-case basis against the framework of exceptions which have been recognised and the fact scenarios which have given rise to those exceptions, either within the Torrens legislative framework itself or recognised categories that exist beyond the framework. The benefit of doing this from the Queensland perspective is that much of that now is contained within this more modern version of Torrens legislation than is the case in other jurisdictions where there's this constant toing and froing between the extent to which things recognised outside of the Torrens framework can impact upon, can impinge upon, can defeat what the Torrens Act ultimately gives. That's a balance to be struck. All right, just as we finish, I'm going to ask you to do something I sometimes do, and that is I would like you all just to take a sheet of paper and to write down 3 takeaway points that you've got from tonight's class. Just write down 3 takeaway points that you've got from tonight's class. All right, and just as we close, if anyone would like to share one of those, then that'd be nice.
Break down what the question is actually asking and address each of those points.
Sounds good. Lisa has indicated that, I think, just to summarise, sort of more careful consideration of those exceptions, but also heightened care as a practitioner. Absolutely, absolutely. I can't indicate to you people how much that is important, and also the fact that you are going to enter practice in whatever capacity as a legally qualified person and professional at the end of the day into a new world of practice by the time you're out there, even than exists at the moment, because the world of legal practice is really changing almost before our eyes. And but the good news, as if one of my colleagues said to me the other day, as if there is good news, there is always good news, because, you know, hope springs eternal, is that you are, in my view, at the cutting edge of this, because you are engaging in this new technological space at the moment. And what you need to grasp as you proceed is how the various levers of law and how the various processes of law are going to actually be caught up and work within this new technological space that we're inhabiting. That's the frontier. And it's scary for a lot of people that are out there and been in practice for a long time, but that's the frontier. And you are going to be part of that frontier, and you're going to be partly defining it, because you've experienced it already in your education. And I think arguably that gives you, to some degree, in some respects, a leading edge, which I'm very heartened about. So, with those parting thoughts, and with storms brewing apparently in some parts of the world, including down here where I am, I think it's getting we're getting buffeted by some of these winds that almost ripped Tasmania and Victoria apart in the last couple of days. I will say adieu, and thanks for joining. And hopefully you can join next week. Not next week. Remember that next week is midterm recess. Please also, just before I sign off, in terms of the timing of things, we missed a class because I was away at the conference and whatever. And as a result of that, I've decided to move the quiz back 1 week to week 7. And I hope that extra week is agreeable to all. But I put a post on, I sent you all an email about that. And there'll be instructions about the quiz very soon. And then during the break, there will also be instructions and information about the moot and how that can be undertaken and completed. And we will continue to progress the merry dance. So, for now, adieu. Thanks for joining.
Thanks, Michael.
Pleasure.
Thank you kindly. See you later.
See you.
Good night all.
Bye.